Now, we would like to welcome Dr. Scott Borlick, Chief Administrative Patent Judge, PDAP of USPTO.
Okay, thank you very much. So I have a presentation about the state of the Patent Trial and Appeal Board at the U.S. Patent and Trademark Office. So first, just the way the PTAB is organized is shown here. This is our management structure. Oh, sorry. Yeah, we need to raise that. There we go. Is that better? All right, great. All right. So shown on this slide is our management structure. We have an office of the chief judge with the chief and deputy chief judge. We have a director review executive who oversees our new director review process. And then at the bottom of the slide, we have 4 operations vice chief judges. Each of them oversees a group of administrative patent judges. We also have a vice chief judge for strategy that helps with a lot of our training and outreach efforts. And then we have a board executive there all the way on the right who is responsible for all the administrative functions of the board, including the hearings operations, the paralegal operations, the IT infrastructure, personnel, all of the things that are needed to allow for filing, distribution, paneling, preparation, and mailing of opinions. So we have about 350 total personnel. We have 240 administrative patent judges and about 100 support staff who you can see in the different ovals here, the different teams that we have at the board. And the idea here is we have a lot of different people helping to make the operation work. So of those 350, I might just add, we also are nationwide across the United States. So we have the USPTO headquarters is in Alexandria, Virginia. We have 4 regional offices across the country, and we're opening a 5th next year in Atlanta, Georgia. Plus, we have many of the judges and staff teleworking full-time across the country. So we are distributed in just about every state in the United States. So this is our caseload last year. The caseload this year, we're just compiling the data. I didn't have it in time for preparation for this talk, but it turns out it's pretty similar. And you can see we had almost 6,000 cases filed at the PTAB. The majority of those are the ex parte appeals from examination, so coming up from the patent examiners. But we had, well, this year it was a little bit more than the 1,239 AIA petitions, but you can see it's 1,200 to 1,300 petitions for review of patents after granting, or what we call post-grant. And then we issued in fiscal year 2023, and again, the numbers are pretty similar for last fiscal year, 2024, about 6,000 decisions, just a little more. Again, most in ex parte appeals, but also in our trials, including decisions on institution. We'll talk a little later about how the AIA trials are structured, but they are structured in 2 stages. There's an institution stage where the board decides whether to institute a trial, and then if one's instituted, there's a trial stage that ends in a final written decision. You can see that we had about 500 final written decisions that took about just under 12 months by by statute, we're required to finish those final written decisions in 12 months, and we're required to get the decisions on institution out within 3 months. You can see we were at 2.7 months there, so we were meeting our statutory obligations. For hearings, so again, 2023, but the last year's data is also fairly similar. So we had a total of 868 hearings. Of those, about half requested public audio feeds. So we do allow the public to listen in to most of the oral hearings unless there's confidential business information being discussed. That's fairly rare, so the majority of the hearings are accessible to the public if they ask. As you can see, though, only about a third were in person, which is interesting. Of course, before COVID, they were almost all in person for the parties, although we did have some judges remote because, again, they even before COVID, they were spread out across the country. So you can see here in person, it was roughly equal between our ex parte appeal in-person hearings and AIA trial hearings. And then the remote hearings, 604 total remote hearings. That means completely remote. The parties, the judges, the court reporter are all remote, completely virtual hearing, and you could see 232 of those were ex parte, and about 372 were the trials. And by the way, for trials, there is a hearing in nearly every case. The appeals, it is more common that you'll have appeals with no hearing requested. It's not requested nearly as often in appeals. So we'll go over some statistics quickly here. These are appeals, and you can see that starting in 2012, we had a lot of appeals in our inventory, nearly 26,000. We have worked hard over the intervening time to bring that inventory down, and now, as you can see, we are just under 5,000 cases at the end of fiscal year 24. That is about a 1-year pendency for the appeals. And this just shows what is the pendency by technology area. They're color-coded by technology, and the overall pendency is all the way on the right there in the black bar. The gray shaded bars are a comparison to the prior year, so you can see the trends in pendency. But overall, just around 12 to 13 months overall pendency. This is the appeal intake by Technology Center. And outcomes. This chart has been fairly steady for a long time. So we affirm the examiner completely in about 60% of the cases. In about another 8%, it's a partial affirmance. About 30% of the time, we reverse the examiner, and then there are a few administrative remands to sort of make up the rest. I'm not really going to talk about our legacy interferences other than to note that they are slowly going away, which was by design. Once we changed to first inventor to file instead of first to invent, this interference was a contest to see who was the first inventor. Those have really slowed down, and someday they will go away. Now, for trials, you can see petitions by trial type. The vast majority are called inter partes review, or IPR. You can see 97%. Compared to 3% post-grant review. That's the other type of trial that we still do. By technology, mostly electrical and computer technologies, although mechanical business method has a large percentage as well. And then you can see smaller percentages of chemical and biotech petitions. As far as the outcomes by petition, What this shows in the orange slice there all the way on the left is there is no trial instituted in about 30% of the cases. So the proceeding is over at that point. There's nothing else to do. About 30% settle, and as we'll see in a later slide, that's split nearly evenly between the institution and trial phase. But if you go all the way to trial, the various shades of blue show the outcomes in a final written decision, which is abbreviated FWD. So you can see that about 27% of the final written decisions are finding all of the challenge claims unpatentable. There's a mixed outcome, so some unpatentable, some remaining patentable in about 6%, and about 6% find all of the challenge claims patentable. So those are our outcomes on a petition-by-petition basis. Petition filings have been fairly steady, although they're starting to creep up again. They had come down a few years ago. Now, this prior year, they've started to come up. This trend continued, is continuing. So we're seeing slightly more on average, this year than we did in the prior year. That institution rate has been fairly steady, but the past few years it has increased a bit. You can see we are about the same in fiscal year 2024 as we were in 23, about 67% instituted. If you look petition by petition, this is another way to count, which is looking at the patent, because sometimes there's more than one petition filed against a patent. So these numbers are slightly higher just because this counts on a patent by patent basis. Institution rate by technology, I'll skip this one. It's because there's not a huge difference other than to note chemical is fairly low. Again, settlements about 30%, and you can see the red and the blue blocks about equally split, more or less, between before and after. I'll talk briefly about the director review process, which was instituted after a Supreme Court decision in 2021 that said the director can review the final written decisions of the board in AIA trials, and we've extended that to institution decisions as well as certain rehearing decisions. We have a process that's on the board website, and we've recently actually put this into rules in the Federal Register. You can see the statistics here. Most of the requests are denied. That's the blue slice. And then there are some other categories, but a lot of the ones that are granted by the director on her own accord. She does have a process to look at the decisions that are issuing from the board and decide whether she's going to take any up. Of course, there are also requests that come from the parties, but you can see that she takes it up, but only in the right cases. If you look again at the yellow pie graph on the right, you can see of the granted requests, 27 came from party requests, 20 came on the director's own accord, or what we call sua sponte, and the 16 is a conversion from a prior process that we phased out after we instituted director review. The last thing I'll just talk about is some outreach efforts that we're doing. We have webinars from PTAB. There's one called Boardside Chat that talks about best practices before the board, and it's a more in-depth look at our practice. We also have one that's directed to people less familiar with the board called Inventor Hour. It's directed to people new to PTAB or independent inventors. We also have a LEAP program that is similar to the kinds of opportunities that Judge Cho Groves talked about yesterday in trying to give newer attorneys argument time before PTAB. We have training programs. We have a mock argument program, all to help newer attorneys. We also have a pro bono program that is free legal help for our appeals, and we've started a new education clinic that is giving information to the public about PTAB, and the information is given by former judges. So that's all that I have, and I see that my time also has expired, so thank you very much.
Thank you very much for the presentation.